Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello, ladies and gentlemen. You are welcome to today's show, Hanging Out with BWF Solicitors. Today's topic is bringing your spouse to the UK as an EEA national if you got married after the 31st December 2020. You can watch this program live on all our social media handles at BWF Solicitors. If you want to send in your questions or contribute to the program, of course, you can do so. And if you prefer to call us live in the studio, the number to call is 0744 861 9711. The number again is 0744 861 9711. With me, as usual, is a partner and also a seasoned solicitor at BWF Solicitors, in the person of Mrs. Eunice Achampon, who will be having the discussion with me, taking us through the process, and also taking some questions that she will be answering. So without wasting much time, I would like to introduce Mrs. Eunice Achampon. Hello, Eunice.
Hi, Vicky. How are you?
I'm good. And you?
I'm doing well by God's grace.
Wonderful. Eunice, before we, as we always do every Saturday, before we, go into this today's topic, do you have any updates for us for the week?
Yes. So, in terms of our immigration rules, last week I was mentioning to us that they've introduced a new concession, or should I say a new policy guidance, which allows those that are between the ages of 18 to 25 to make applications and have considered by the caseworker at the Home Office whether they can be granted further leave to remain longer than 2.5 years or indefinite leave to remain,
Yeah.
which is good for those that, for instance, have applied as dependents of Zambrano carers. And usually, if you are above the age of 18, you are no longer seen as a dependent. And so, for instance, you've now reached the age of 18 and you know that you can't apply for settlement because you're above the age of 18.
Okay.
So, most times, those applicants will be making an application for private life under 276 AD of our immigration rules to say that they have lived here more than half of their lives. They are above the age of 18 but under 25, and they would like to make a private life application to remain in the UK. And in that sense, once they've been granted 2.5 years, they will have to go on and complete 10 years of 2.5 years before they can even apply for indefinite leave to remain.
Remain.
So, in such a circumstance, it means that, of course, they will have to repeat this continuously for a 10-year period. And this concession being brought means that, of course, they will have to show that they have had valid leave for at least 5 years. And then they will have to also show that they are between the ages of 18 to 25 and they can make a valid application for for private life under our immigration rules. And also the fact that they have also shown that they were people that were previously granted leave under 276 AD of our immigration rules. So it also means that once they can show that they've completed this period of 5 years and
Yes.
also shown that they have good social ties, they have been deeply rooted in our, should I say, in our UK way of life and culture. They will also have to show that, of course, because of their age and the fact that maybe they've lived here for a very long time, even before they were allowed to make their leave to remain application, and also the fact that they have welfare and health concerns, and that's why they would want the Home Office to consider giving them indefinite leave to remain rather than another 2.5 years leave to remain. So these are some of the things that, of course, they will be looking at. But it's good news for those who are between the ages of 18 and 25 who are considering even going to university and the rest of it. So this comes as good news for those applicants who are looking to have indefinite leave to remain granted to them before the 10-year period is up.
Wow. Okay. Right. Ladies and gentlemen, if you've just joined, well, I've seen people have started joining us. If you've just joined us, you are at the right place at the right time. This is Hanging Out with BWF Solicitors. With me is Mrs. Lawyer Unisa Champong and your host, Vicky Newton. Today's topic is bringing your spouse to the UK as an EEA national if you got married after the 31st December 2020. If you would like to contribute to this program, suggestions, comments, you can do so on all our social media handles, Facebook, YouTube, just to mention a few. And we'll be able to pick that up. If you prefer to call us live in the studio, you can also do that by calling 0744 8619 711. Laura Eunice, I always do ask you before you decide what topic you want to treat, whether there's any reason behind, choosing this particular topic when there are other topics that we could have treated today.
So I think a lot of people haven't realized that, yes, we are out of the AU and now thinking, okay, what do I do in regards to, for instance, making a spousal application. And I do get a lot of queries in regards to what options are available. And of course, we still have our EU settlement scheme route still ongoing, but this is a route that obviously people may not necessarily be aware of. And so it means that it makes sense to let people know that there is also this option available as well, so that if there is any need for you to bring your wife, or you end up getting married sometime in the future, this route is always available to you. Yes.
Okay. All right. So, now, if I may ask, why the date 31st, 2020? And does it matter if an EEA national was married before or after?
Okay. So when we talk about 31st of December 2020, under our immigration rules, that's known as the specified date. So that date was the date on which the UK decided free movement was ending. And so, where before we had EU nationals coming in and out because of free movement and the treaties that obviously entrenched this in our UK laws as well, that meant that an EU national from any EU country could go and come as he liked, as long as after a period of at least 3 months, which is initial period of residence, they can show that they have found work in this country and they are willing to allow their family members to come and join them. And it was a matter of right. And so, of course, EU nationals could freely come and go without visas and the rest of it.
Yeah, right.
But then by the 31st of December, here comes our deadline of us saying no longer would EU nationals be able to come in and out. And so at 11 p.m. of the 31st of December, EU nationals could no longer come in and out of the UK as they used to. And therefore, every EU law or treaty that entrenched this right could no longer be applicable as and when they thought they could rely on it, basically. And so, as of the 1st of January 2021, the UK said if you're an EU national or a third country national and you want to come and live and work in the UK, you will have to apply under our points based system. And that was when, of course, people were thinking, okay, so would I still be able to bring my family member as an EU national into the UK if I needed to? Yes, of course, you would still be able to bring your family into the UK.
Okay.
Um, it's fair to say that we've said a lot about the EU settlement scheme, and not only is it for EU nationals who were living in the UK before the 31st of December 2020, but it is also for them to bring their family members if their relationship was formed before the 31st of December 2020. So that EU settlement scheme route is still available.
Yeah.
But where a relationship was formed after the 31st of December 2020, then what else is available? How else can they also bring their family members? And under our immigration rules, we have Appendix FM of the immigration rules, which is specifically for family members. And so, how do you bring your spouse into the UK, your husband or your wife, that you have now gotten married to, or that you are thinking about getting married to, or maybe you haven't even thought about getting married, but later on in the future, if
Mm.
you choose to get married, how would you be able to bring such a person to the UK? And of course, um, we know that from that 1st of January 2021, it
Mhm.
became a lot easier for people to know what routes and what options were available to them if they could not make the application under the EU settlement scheme. So, yes, there is that difference, but hopefully, I've made it a bit clearer.
Right. Yes. Yes. You've indeed made it Very clear. But Lawyer Eunice, what kind of requirements is needed to satisfy, to be satisfied under in the immigration rules?
So when you look specifically at Appendix FM of our immigration rules, and you look at the section regarding partners, you find out that a partner can be the person that you've lived with for a period of 2 years, but more specifically, you have somebody that you've also um, gotten married to. So if you are married and you have a marriage certificate to show that this person is your husband or your wife,
Yeah.
then of course you can show that as proof of your relationship. And also, when you look at the fact that Appendix FM also has certain requirements that need to be met. So you have these three main requirements, including our suitability requirements that need to be met before
Yeah.
a person can apply under this route. So, firstly, they're looking at the relationship. Can you show that, of course, you're married to this person? They want to know that you're both above the age of 18, that you both have not um, been in any prohibited relationship. So, for instance, if you were married, that of course you are now divorced before remarrying this person. And also, they want to know that you're in a genuine and subsisting relationship. So, this marriage is, of course, something that you both have intended to go into with every intention of living together and staying together. And when it comes to all these things, it's quite difficult sometimes to show that you are in a genuine and subsistent relationship. But there are things that you can provide. So that may include your communication with each other. It could include things like photographs. It could include the fact that you travel to see each other. So those kind of things help in showing that your relationship is continuing, your relationship is indeed genuine. And when it comes to things like you showing that you are able to meet the English language requirement, which is also one of the requirements that have to be met, then they want to
Mm.
know, have you been able to take an approved English language test, which is an IELTS? So at least you should be able to meet a level A1 in terms of doing the IELTS. If you haven't done an approved English language test, have you got an undergraduate degree or a master's degree that has been assessed by ECTIS? And of course, if you are saying that you have had an undergraduate degree which has been assessed to meet the required qualification framework of level A1, then at least you're fine. If it's above A1, even better. And then it comes on to that financial requirement. So now I have to meet something we call a financial requirement. And do I have to show that I am earning a specific amount? Yes, you should be able to show that you are earning at least 18,600 per annum. And this is for the EA national who is residing here in the UK. So this EA national, whether they have pre-settled status, which is limited leave to remain, or settled status, which is indefinite leave to remain, they should be able to show that they have that income available. And so they should be able to show that at least if they combine their income from one job or two jobs or how many other jobs they have, they would be able to meet that threshold of
Mhm.
18,600.
Yeah.
And then, of course, you want to be able to show that you can also accommodate this person when they come. So, if this person comes, would they be able to have suitable accommodation? And they want to know that at least once this person comes, they will have a place to put their head.
Mm.
And if you have a tenancy agreement, you can use that as proof that they will have suitable accommodation. Or you can also use your mortgage deed. Or if for one reason or the other you don't have a tenancy and you're living with somebody who is willing to provide a letter as such, then they can provide you with a letter to say maybe you are renting a one bedroom, and this is suitable in terms of our Housing Act
Yeah.
of 1988. So, yes, of course, if you are able to show that indeed you are in this genuine and subsistent relationship, that the person who is going to join you, who is the spouse, can meet the English language requirement, that you, who is the EEA national, is also able to meet that threshold of 18,600 a year, and that this person, when they come, will be able to have suitable accommodation for
Mm.
themselves, then of course you will then be able to say you can be eligible to apply under this route. And like I said before, you have also the suitability requirements, where, for instance, if a person who is making this application has previously come to the UK before and they were an illegal immigrant, or they basically overstayed their leave, there will be that automatic ban of 1 year. Or, for instance, if there has been some form of deportation order or exclusion order, then that person will not have their application approved, because those are, should I say, mandatory reasons for them to refuse your application. But if, for instance, you have any other reasons for which maybe you think you may not be able to apply, then of course you might need to seek legal advice, because when it comes to things like false representations and other applications that people have made, it's always suitable and better to seek legal advice as to how to go about it rather than doing it yourself. Yes.
Okay. Okay. All right. Lee is asking, I know you're giving us the requirement. He wants to know which documents does he need for such an application.
Application. So, in terms of the application, once you are able to show that you meet the requirements, like I said, you should be able to show that you are in a relationship with this person, which means that you are the spouse.
Mm.
And therefore, if by way of your marriage certificate you are showing that you are married to this person, your marriage certificate will be the first thing that you would provide.
Yeah.
Evidence of your relationship continuing could include your communication, whether it's messaging or phone calls, or the fact that you travel to see each other, photographs, if you do remit money to them, things like money transfer receipts. So it could be anything that shows that you have this continuing relationship with this person. And then, of course, when it comes to the English test, you can show by way of your IELTS certificate. So that is one way of meeting the English requirement. But then, if you have an undergraduate degree or a master's degree and you have had it assessed by ECTS, you would use that degree certificate and the actor's confirmation to show that you meet the required skill level, or should I say, required um, English framework level.
So,
And then, in terms of the financial side or the financial aspect, you should be able to show that you are employed. If you are self employed, then of course you'll be able to give to the Home Office your 12 months bank statements, invoices, self assessment records, tax returns, evidence basically to show that you are doing everything that is required of you as a self employed person. And then, if you are employed, you can provide your 6 months bank statements and 6 months pay slip and a letter from your employer to show that yes, you are employed and this is the income you are getting. For accommodation, like I said, having the tenancy agreement is good. You can also provide your mortgage deed if you own your own home. But if you are not able to provide a tenancy agreement or a mortgage deed, and there is somebody who is basically lending you or helping you in terms of accommodation, they too can provide a letter of support to say that you are living in a one bedroom and therefore
mm,
um, they are okay with you having your spouse come and join you in the property as well. So these are a few of the documents that you could provide in terms of making such an application. Yeah.
Okay, right. Ladies and gentlemen, this is Hanging Out with Vicky with BWF Solicitors. The topic for today is bringing your spouse to the UK as an EEA national if you got married after 31st December 2020. With me is our resource person, a seasoned solicitor, and also a partner at BWF Solicitors in the person of Mrs. Eunice Achampong. She is going to take us through this topic. If you would like to send in your questions, please do. I would like to hear from all of you. I believe that I don't think it has to be one-sided. So please send in your questions. If you have any queries, if you want to comment, we are here to hear from you. I believe with that, the show will be more interesting. So please do that. And also share to all your friends, loved ones, and colleagues. And if you believe what we are discussing will be of help to someone, please share to that person so that the person can join into the program. I'm your host, as usual, Vicky Newton. Lawyer Eunice has taken us through how this came about and also the requirements needed to make this application. Before she also did mention that the documents needed in order to make a successful application. If you like to call in the studio live, you can do so on 0744 8619 The number again is 0744 8619 I would love to hear from you. Right, Lawyer Eunice, I've got some questions coming in at the moment. Let me take the first question. Yes. Yes. This viewer says he wants to stay anonymous for some reason. He says, I was previously married and I have met someone else who I knew before back home. I'm an Italian national who now has settled status. I am now in the process of getting a divorce and would like to know if I do get married to this lady, what application will I be making for her and which documents will be needed? I think you've touched on the documents already, but
Yes.
yeah,
Yes. So he's saying that he's an Italian national and
yes,
he's got settled status in the UK. So that's the same as indefinite leave
to,
to
yeah,
remain
yeah.
under the EU settlement scheme.
Hmm.
And he would like to find out what application can be made. And he's also in the process of a divorce right now.
Yeah,
So obviously, like I said before, if you are currently in the process of divorce and you are looking to get married, then of course, once the divorce has been finalized, you are free to marry whoever you choose to. So of course, once he has finalized the divorce and now believes that he's a free man, he can go to Ghana or wherever he comes from and have the marriage done as necessary. So when it comes to making the application, he will be making the application under Appendix FM rather than under the EU settlement scheme because of the fact that the relationship was formed after the 31st of December
okay.
2020. And so the reason probably he's thinking what application should I make is because of the fact that he probably also made his application under the EU settlement scheme. And he also think that is applicable to his family member, but not in this case. So as I mentioned before, there are requirements under Appendix FM that need to be met. And so if he was listening, it will have to be the fact that he's in a relationship which is genuine and subsisting. He will have to show that this marriage that he's gone into, of course, he was free to marry at the time, and so he will provide his divorce certificate and then the marriage certificate, which shows that he got married after. And of course, if there are visits to see her, he will provide travel itinerary and the rest,
Mm.
including photographs as well, if he wants. Things like their WhatsApp, their phone call history, those sort of things also help in showing how genuine and subsistent a relationship is. And then, of course, in terms of the English language requirement, as long as she's able to provide an IELTS certificate or an
Okay.
undergraduate certificate with ECTS confirmation, that should meet that requirement. And then, in terms of also the fact that he is working, so if he's working, his income, which is his gross income,
Yeah.
should be more than the threshold or at exactly at 18,600. So if
Okay.
he's saying that yes, I am able to meet that requirement, of course, then he should be able to also provide evidence of accommodation, that he is currently being accommodated and that he'll be able to accommodate this other person who will be coming to join him here
Oh,
in the UK. And like I previously said, when it comes to suitability requirements, if this person who is making the application has made previous applications before and they need advice as to how to go about this, then they would need to provide more information and also seek legal advice in
oh,
terms of making such an application.
okay. Okay. Right. Okay. The second question comes from a Dutch national. And here's the question. I'm a Dutch national and I've met someone I would like to get married to. She currently has a visit visa, which is due to expire in 2 months' time. We are hoping to get married in a few days' time. Will she be able to make any application from the UK, Lawyer Eunice?
So this one is also a bit tricky in terms of the fact that this person is not even outside of the UK. This person is currently in the UK. Um, he said that he's a Dutch national
Yes.
and he's obviously got pre-settled status, which is limited leave to remain. So, um, as I stated before under Appendix FM, you also have the requirement where the person who is an EA national can either show
Mm-hmm.
that they have limited leave to remain or they have settled status, which is indefinite leave to remain.
Yeah.
And so, yes, with this person who has limited leave to remain of 5 years, he wants to know if he can also allow his partner who is here in the UK to make the application under the same route. And so, of course, there isn't much information in regards to how long they've known each other. But he
Yeah.
says that the person is here with a valid visit visa and they have 2 months left to go. So I'm sure, um, based on the 6 months that they were given, she's just left with 2 months to go.
Mm.
Of course, when you are thinking about making an application like this, it's always best to also seek legal advice because of the fact that this person is also here in the UK. When it comes to how long they have known each other, we are not sure, but they want to get married.
Yeah.
They want to be able to make an application to also stay in the UK. And so, in that circumstance, if for instance he's saying that they've known each other for a long time and he now wants to make the application, then of course, um, he will have to provide evidence of the fact that they are indeed in a relationship. So either that they are partners or they are married. So under
Okay.
Jen, 1.2, you should be able to show that indeed you are in a durable relationship. So that will include the things that we usually would say show that somebody is in a durable relationship, either that you've lived together for a period of 2 years, or maybe by chance they have a child together.
Yeah.
So that is one thing that they can use as proof that they are indeed in a durable relationship. But when it comes to marriage, you don't have to show proof of living together for 2 years.
Okay.
All you need to show is that you are married, and therefore the marriage certificate is enough to prove your relationship. So if the case is that he now wants to get married to this person, then of course he should be able to show that now this person is his wife. Or as I said, if they have been in a durable relationship, then they should be able to show that, of course, they've been together for a long period of time. And of course, they are now thinking about making this application. And in that sense, when you look at the immigration rules, it's very specific about those that are making the application in country. So you're not looking at it from a perspective of somebody who is making it out of the UK, but now you're looking at it from a perspective of somebody who is making an application for leave to remain,
Right.
yeah, in the UK. And so, in that sense, that would mean that, of course, if this person were to make the application, they will have to now think about how they will be able to meet the requirements. And we all know that when it comes to our normal immigration rules, they're saying that if you have like a visit visa, for instance, you would not be eligible to make the application under the immigration rules. But we also know from our statement of changes. So, statement of changes is things that the Home Office and her department bring to show that they are changing the rules in a specific way. And so, when they change the rules, they make it lawful for other people who the category that they are speaking about can apply to. And when it comes to those that are spouses of EA nationals, it means that, of course, when you look at the statement of changes from 2 months ago, those that were on visit visas could not be able to make an application under this said route. But now
Okay.
that they have now made it clear that those that are spouses of EA nationals are now eligible to still make applications, even though they are, what should I call it, not usually eligible to make these applications, they are now able to also make these applications as well. So that helps in terms of them meeting the immigration status requirement because, of course, if you are here illegally,
Yeah.
then that means that you will not be able to meet the requirement, and therefore you have to show that there are exceptional circumstances that apply to your case. And usually, if there are exceptional circumstances, it will either have to be the fact that you have a child together who is under the age of 18, and it will be unreasonable for this child to return to your country of origin, or it would mean that, of course, if the both of you are in a relationship which is going to be very difficult or is going to be very harsh for
Yeah.
the both of you to continue your life in that country where you are from, then you will have to prove that you will have difficulty in continuing your family life in
Okay.
the country where the other person is from. So for instance, if the person was not able to meet the immigration requirement and they were saying that there was um, good reason for that, and maybe they had a child together, and therefore it will be unreasonable for this child to continue their family life outside of the UK. They'll have to show that this child is a qualifying child, first of all,
Yeah.
because the father has limited leave to remain. So, is this child a British child? Hardly. Is this child a child that has got 7 years continuous residence in the UK,
Yeah.
I'm not thinking it's likely. Um, if they are able to show that this child is settled, of course, then they will be able to make the application, but the child will not be able to meet any of those requirements for a qualifying child. And so, of course, that would not help in their situation. And then the second option, in terms of insurmountable obstacles, means that they should be able to show that it will be so hard for them to continue with family life outside of the UK. And because that's such a high threshold, it makes it very difficult for people to even say that they are trying to meet that requirement.
Yeah.
Um, so it's one of those things when you are making an application in country as a spouse,
Yeah.
it's always best to seek legal advice, because you have all these um, requirements that have to be met, and you have to be able to show whether your circumstances are literally what the law requires from you. And so, of course, if you are making such an application and you're thinking, would I be able to meet these requirements? Then of course you should be able to seek legal advice as to how best you will be able to meet the relationship requirement, the immigration status requirement, the English language requirement, and also the financial and accommodation requirement. So when I was talking about somebody applying from outside the UK, I didn't mention immigration status.
Exactly.
But when you're making the application from the UK, you have to also consider that immigration status requirement as well, which is also one of the requirements that have to be met in
Mm.
order for that person to meet the rules and then also make the application. But as I said, if they're not able to meet it, what options are there? And that was when I mentioned whether they have a qualifying child and would be unreasonable for that child to return to their country of origin, or whether both for both of them it will be unduly harsh, or basically saying to them that you returning to your country of origin will be uncalled for, and basically very harsh for the Home Office to say that you should return when, for instance, you have very terminal illness and you are not able to be treated, or it
Yeah.
might mean that you are somebody who, for instance, has no clue of the language in that country.
Okay.
There might be a lot of turmoil in the country that you will be returning to,
Mm.
and that's why it will be unduly harsh. So it's quite a high threshold, and if you were to ever make such an application, that will be necessary for you to also seek some legal advice as to how best you can meet the requirements before making such an application as well.
Okay. So, if this application is refused, is there any way they can appeal?
So, if for instance they say that, well, we think that you don't meet the requirements and we want to refuse the application, when you're making an application like this, we always tend to look at it from a human rights perspective. So, if you consider the fact that this person is married, or this person is in a relationship with their spouse, and they are looking at it from the perspective of the fact that family life has been formed,
Yeah.
then of course, once you are able to establish or make that claim that you have that right to family life, to be able to live with this person, to enjoy life with this person,
Yeah.
then of course that should warrant a right of appeal in terms of making an application under Appendix FM. So usually most human right applications will be granted a right of appeal, and you will have 14 days in which to obviously lodge an appeal and then make it known the reasons or your submissions why the Home Office was wrong in making that decision.
Okay. All
Yeah.
right. Great, great, great. Ladies and gentlemen, as usual, this is Hanging Out with BWS Solicitors, and today's topic had been bringing your spouse to the UK as an EEA and national if you got married after the 31st of December 2020. And Laura Eunice has been taking us through the topic, um, answering questions, and also taking us through what the requirements are and the necessary documents to submit. If you still want to contribute all in the program, you can do so. Sending your message via Facebook, YouTube, or you can call me live in the studio on 0744-8619-711. If you'd like to contact Lawyer Eunice and her team at the after the program, she'll be leaving her details for you to get in touch with her for further assistance. Um, Bear with me 1 minute. I think a call is coming through. Hello. Hello. Afternoon. Are you calling in to ask a question? Okay, hold on a minute. Yes. Hello, caller. What's your name and where are you calling from?
My name is
Ernest. Okay.
Yeah. And my question is in regard to I have a sister who is here and he got a permit through extended family, EU extended family.
Okay.
But currently the partner is in with a student visa and they want to know is there any other means the lady can get the partner a resident permit here since she's also being sponsored by someone.
Okay.
And the second question is, if by chance they give birth, what will be the status of the child
Okay.
in terms of residency? Yeah.
All right. Laura Eunice, did you hear the two questions?
So he's saying his sister is a dependent on an EA national
Exactly. And her husband is on a student visa.
visa. Okay, so he wants to know whether she can obviously make an application for her partner
Yes.
to join her as such. And then the second
The
question was
second
to do
question is
with
when they have a child, what will be the status of that child?
okay. So in terms of the partner, so currently he's on a student visa. So I'm not sure how long his course is for, but usually they give you a student visa for the duration of your course.
Of course, yeah.
Yes. And so in that sense, he's okay until the leave expires. When it comes to her being a dependent, obviously I'm not sure how long she's been on the dependency route for. So for instance, if she made the application in 2019 and then of course she's got 5 years to go, which means that by now she's done 2 years and then she's left with another 3 years.
Yes.
So that would mean that she will have to obviously wait until she's got settled status because as a dependent, she would not be able to make an application for her partner. So what I was talking about was referring to EA nationals and not their family members having pre-settled status.
Okay.
So as a family member who has limited leave to remain, then of course she has to look at the fact that she will not be eligible under the immigration rules to make an application for that family member. But if she obviously gets her settled status or if she is able to get indefinite leave to remain, then of course she can make an application for her spouse.
Okay.
In that sense, when we say that she's going to be able to make an application for her spouse, that may not necessarily mean that the application will be successful. So, as I was saying, you have to be able to meet the requirements, which include the relationship requirement, the immigration status, because he's now in the country. Then, of course, he should be able to meet the English language requirement, and then they should be able to meet the financial requirement of 18,600 gross
Okay.
pay. So, if for instance, he has 3 years student visa, and she's also left with 3 years to go until she gets her settled status. She should be able to get her settled status before his leave expires. before they can make the application. So if, for instance, she's got 5 years residence or leave limited leave to remain, and then she's saying that I'm eligible to apply for indefinite leave to remain in 3 years' time, she should be able to get her indefinite leave to remain
Mm-hmm.
before making the application for her husband. So
Oh,
if her husband's student visa is still extant, so it's still valid, by the time she gets her indefinite leave to remain, then he can make the switch from student visa to the spousal route. But if for any reason that visa expires before she is granted indefinite leave to remain, that is when the child and the insurmountable obstacles kick in. So either that they have a child together who is settled,
mm,
or they have a child who is British,
mm,
or they have a child who has lived in the country for a continuous period of 7 years. If they don't have a child who is settled, so if at the time she's making the application for indefinite leave to remain, the child is born, and therefore she's saying that I have a child, and now that I have indefinite, I want to register this child as British because I gave birth to this child before I had indefinite, then that's fine. But if they don't have a child, then that would mean that they will have to fall on the second part of the exceptions to the rules. And
oh,
that means that they have to show that both of them will experience insurmountable obstacles if they were to go back to the country where he is from. So, if that were the case, then that would mean that they will have to really meet a high threshold in order to meet that exception. And so, when it comes to circumstances like this, I would always say it's better to seek legal advice. So, I'm not sure if he understood what I said, but I hope when the time is right, they will be able to seek further legal advice in terms of making such an application.
oh, okay. All right. Thank you. I think I lost him whilst,
Yes.
you know, listening to your solution to the problem.
Yes.
Uh, he's watching us
Of
right now,
course.
so I think at the end of the program, he will be able to get your contact details and contact you for further assistance and advice. So,
Right.
Eunice, if you could quickly round up for us and also leave your contact details so that someone like Ernest will be able to get in touch with you for further advice or help.
Okay.
Please.
So, as I've been discussing today, in regards to EA nationals making applications to bring their spouse, of course, when it comes to making this application, the key date is the 31st of December 2020. If you can establish that there was a relationship before 31st of December 2020, then this is not for you. This is for those who have established relationship after the 31st of December 2020. So if you're an EA national, you're looking to get married, or you got married um, from the 1st of January 2021 onwards, then of course the British government have said you can make an application for your spouse to join you, looking at the rules under Appendix FM. As long as you are able to show that you are able to meet the relationship requirement, you are able to meet the English language requirement, you are also able to meet the financial requirement and accommodation requirement. Then, of course, if there are any suitability issues in terms of you making the application, then you should seek also further legal advice. If you fall into this category, or you have any other issues apart from immigration, because we don't only deal with immigration matters, we also deal with other issues in regards to family and children, and also the fact that there might be civil issues where people need um, support or legal assistance. Um, of course, it will be good for me to put our details out there so that you can phone to speak to any one of our solicitors who are also available to answer or to give you advice. As Vicky said, I'm one of the solicitors at BWS Solicitors, and we are situated in London. Our address is the fourth floor of Anne House, 214 to 218 Tottenham High Road. The postcode is N154NP. So it's N154NP. Our office telephone number is 0208 493 7340. So 0208 493 7340. And we are open from 9:30 a.m. to 6 p.m. Monday to Friday. My office, or should I say my general contact number out of office hour is 075 3581 3910. So 075 3581 3910.
Thank you, Lawyer Eunice. Ladies and gentlemen, I don't like it when we come to the end of the program. We have to. We have to. I would like to also inform you that BWF Solicitors will be having another legal education program on Facebook in about 2 hours' time at 4 p.m. And the topic for the program is, can I lose my house and land to my caretaker after 12 years of occupation? If you are interested in this, I think I would like to listen to this, because this is very common in the Caribbean, Africa, isn't it? You leave your empty property with a caretaker, then after a number of years, he's got all his family, everyone staying in that property, and they'll tell you that the property is mine because I have been living here and taking care of it. So I think that's a very educative, it is going to be interesting, because I would like to know how that can be resolved, and also why should someone believe that being a caretaker of a property for 12 years, you have every right to take over the property. How is that possible? And if that happens, how can you get your property back? So I think I'll advise each and everyone to tune into this interesting topic. I will also do that to at least get some wisdom from it, and advise anybody who goes into such problems. So please tune in at BWF Solicitors on Facebook Live at 4 p.m. And the guest is going to be Mr. Bernardo Wusu, and Mr. Oreku Frimpong is going to be the host. So tune in. It's going to be interesting. I will be there. And if you joined into this program at the latter part, I would advise you to go to our YouTube, Facebook page. We have a recorded version there, so you can comfortably in your, living room just press on play, and you'll be able to watch everything from the beginning to the end. So don't be disappointed that I wasn't there from the beginning. We've got a recorded version on our Facebook and YouTube page where you can just go back and watch everything from the beginning. And of course, if you have any queries because you missed out during the beginning of the show, you can do so by contacting Lawyer Eunice on the contact details that she's given her. So on that note, I'll see you possibly at 4 p.m. on the BWF Solicitors Facebook page. And also looking forward to seeing you again, same time, Saturday. Take care of yourself. From me to Eunice, we say bye-bye. Have a lovely weekend.
Based in London, We are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernard Owusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernard Owusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.